Hello and welcome again to Business Immigration Online. Today we're going to start a discussion with the first actual true work visa, and there is nothing better than start with the H-1B. H-1B is probably the most known and the most controversial work visa in the public discourse. The reasons are that it's highly visible, it brings in employees from other countries, and some people see it as a means for companies to displace US workers. There were some very notorious situation where abuse of the visa was found. On the other hand, proponents cite to the fact that there are critical shortages in workforce in this country, and many people are not able to start new businesses or fill up position that they have in their organizations because there are no U.S. workers who are qualified or not enough of them to fill up all those positions. There are some areas where we know we have critical shortages, like in healthcare, and there is more controversy whether there is really shortages in high tech and so on. But it seems like the shortage is real, and companies in Silicon Valley and otherwise have a real major problem filling up positions. What are the major characteristics? The H-1B is one of those few non-immigrant visas that has numerical limitation. And the numerical limitation is currently 65,000 by law. Out of them, there are about 5,700 reserved based on treaty with Chile and Singapore. And there is an additional 20,000 visas reserved for applicants with advanced degrees from U.S. universities, meaning master's or higher from a U.S. School. Um, in most of the recent years, in the last 10 years or so, the numbers have been reached very early, if not right at the beginning of the application period, the petition period. Um, H-1B, you can apply up to 6 months before the beginning of the fiscal year. And the government's fiscal year starts October 1st, so the application period opens on April 1st. And the initial application period lasts 5 business days. After the first 5 business days in April, USCIS check if sufficient petitions were filed, and if there were sufficient, or the number of petition exceeds the numerical limitation, then USCIS has to conduct a lottery between all those who applied in the first 5 days. If the number, if or the cap has not been reached, people can continue to file petition until that day when USCIS announces that sufficient number of petition was received to meet the statutory quotas stated here. And remember, those numerical limitations only apply for new visas. And remember also that although the application is in April, it is for employment that will begin on October 1st. It's not for immediate employment. H-1B, as a result of the conflict over its purposes and whether this is a good thing or bad thing for the country, has a labor condition application that must be filed with every petition. This is an attestation that each employer must make to the Department of Labor to confirm that they will not use the foreign national in order to adversely affect similarly situated U.S. workers, depress wages, break strikes, um, and so on, but rather treat the foreign national the same as comparable employees that are U.S. workers. The LCA is done electronically and it details the wages, the location, the position, and must be maintained in a special public access file that each H-1B employer must keep for inspection by anyone who wants to review them. And now, after we talked about how to get it and what it is, now we're going to see who is it for. H-1B is intended for skilled labor, meaning people who are professionals and required to fill a position that requires either at least a bachelor's degree or its equivalent as entry level, or that they need to apply a complex body of law that is consistent with what is usually imparted during an academic bachelor degree in the United States. Now, instead of a degree, it says here equivalent. We're going to talk about it a little later, but it doesn't necessarily have to be a degree um, from a U.S. university. It can be an equivalent, it can be experience and a foreign degree or a combination of the two, and we'll see this in a little bit more detail later on. There are certain subgroup of H-1Bs reserved for Department of Defense, special project for the Department of Defense, and some for foreign physicians who are subject to the 2 years home residency requirement and looking for a waiver. We not going to discuss those groups in further detail, but you can find the information um, online on the USCIS website and in the reading material. Very important, there are some employers that are exempt from the numerical limitation by the nature of their activities, and these are mostly universities and research organizations that are non-profit or governmental research organization. Those organizations can always seek H-1Bs regardless of the quota situation, and the person, the beneficiary, can always start working right away. This is a major advantage for this type of visas, and it's very um, um, beneficial to those employers. Who the H-1B is not for. So it's clearly not for unskilled labor. It's also, as we saw, not allowed to use that visa to displace U.S. workers or to depress wages and so on. And generally, it requires the employer to keep control and a real employer-employee relationship with the foreign national. Therefore, staffing companies where the employees are sent to other employers and work based on the control of those employers is not allowed under the H-1B scheme. It also not designed for self-employment. We will see that there are situations where there are entities that are controlled by the foreign national, an legal entity like a corporation, a limited liability company, or a partnership. These are separate entities. However, USCIS requires, again, the existence of control, meaning that there is some way for the employer to monitor, control, and discipline or terminate the foreign national. We're going to talk a little bit more about that later on, but as a general rule, one cannot file for themselves. A foreign national cannot file on his own behalf for H-1B. Um, how does it work? When a visa petition is filed with USCIS, the visa is employer, employee, location, position, and duty specific. We saw that the LCA contains this information. The petition, USCIS petition, also included. Um, if approved, dependents, which means spouses and unmarried children under the age of 21, are able to accompany the H-1B beneficiary on H-4 status. This status, of course, allows the people to stay together as a family, but does not allow the spouse or anyone else to work. We will see that there is now a very important exception to this rule, but as a whole, this group of people in H-4 cannot work. They can do a lot of things in the US, like go to school and so on, but they cannot accept employment by a US employer. The limitation on the time for the visa is 6 years, as we said, unless there are some other circumstances, and that time is counted um, whether the person is in H-1B or in L-1, and it's an aggregate time with all employers. Um, the visa H-1B, thankfully, has dual intent. So an applicant for a visa after the petition by the employer was approved and the foreign national applied for a visa It is not required to show home country ties. They don't have to show that they have a residence in their home country that they don't intend to abandon, and so on. So it makes life somewhat easier for these visa applicants. There are special provision in AC-21, which is a short name for the American Competitiveness in the 21st Century, which is an act of Congress um, that has several provisions that allow for extension beyond the 6 years in situation where the foreign national is pursuing a green card, or more correctly, their employer pursues a green card on their behalf. Um, we're going to talk about it a little bit later on in the course, but this is a very important provision that reflect the lengthy wait times that some foreign nationals are subject to. We're going to continue the presentation in the next separate video.